Hello, everyone. Good evening and welcome back. Today's topic for discussion is Doctrine of Pendence from Transfer of Property Act. So before we begin, let me just ask you one question. Have you heard of Pendence or pendente lite during your college days? If you have, you must recall and understand the concept of it as well. Okay, the concept of doctrine of pendence from your college days, and try to correlate it with the idea of Transfer of Property Act. The doctrine is based and is coming from Transfer of Property Act under the Indian jurisdiction, but at the same time we also understand that this is an equity doctrine, right? So primarily when we talk about section 52 of the Transfer of Property Act, we get to understand about doctrine of pendence. So let's try to understand. I hope my screen is visible to all of you. Yes?
No, ma'am, not yet.
It is not visible. Okay, just a second. I'll fix it. So till the time when I'm fixing this, let me just ask you that what do you think is the basic concept of Transfer of Property Act? Have you ever seen or have you ever gone through the object of this particular law? If you have, you must have understood that the idea is to promote transfer of property rather than accumulation of property, right? So promotion of transfer of property is the pro or is the benefit that you get because of this particular legislation. But at the same time, is there any embargo? Is there any situation wherein while you are transferring the property, there is a pending suit related to the same subject matter, and in that particular situation, what will be the outcome? If the outcome goes against you, or if the outcome is against the judgment debtor, so to know what will be the conclusion or what will be the effect of the same on this particular subject matter, that is the immovable property. Now, before I begin, let me just ask you a few more questions, follow-up questions. If you have read Transfer of Property Act, do you understand the meaning of immovable property? Because if you read section 52, why am I referring to section 52? Because that is the provision related to doctrine of pendence. Okay. So let me just share my screen as well with you, and then we can proceed. Okay, I hope this is visible now to everybody. Yes, is this visible? Okay. So if we refer to section 52, I have written and I've highlighted the provision in front of you. Wherever we need to stop, whenever you are reading any particular provision, I request you that you try to highlight and find out the essential ingredient out of that particular provision. Okay. So what all will make or what all will lead into a situation of section 52? During the pendency in any court having authority within the limits of India. Okay, so firstly, we are talking about pendency. So what is pendency? We need to understand that in any court having authority. So we are now talking about court which has authority. Okay. And the first one is pendency. So this is how I read. When I'm reading from my Bare Act, I highlight all the essentials like this. Within the limits of India, excluding Jammu and Kashmir, now this will be taken away or established beyond this particular, of any suit or proceedings which is not collusive. Okay. So we have to understand what is this term suit or what is this term proceeding. And also the suit and proceeding must not be collusive in nature. So what is collusive? We have heard of this term in our criminal law classes, ma'am, but what does it mean here? And in which any right to immovable property is directly and specifically in question. So we also have to understand that there is an immovable property which is the subject matter of a particular suit or proceeding, and that immovable property is the same thing which you are trying to transfer to a person. Okay, so any right to the immovable property is directly or specifically in question. So what this directly and specifically means? The property cannot be transferred or otherwise dealt with. So these are all essential that I'm highlighting. Do you see how many essential points are there? It must not be transferred and it must not be otherwise dealt with. So you may have a brief understanding of the term transfer, but what does this otherwise dealt with means here? By any party to the suit or proceeding. So any party, again, it can be you, it can be the plaintiff, it can be the defendant, or can it also be a third party or a stranger party? These are all points that you must understand from where questions can be asked. A question in your preliminary examinations only asking you about what all terms are used in section 52, suit, proceedings, both or none. So you must be very thorough with the terminologies from the provision. So that's how you read from your bare act first thing. Then you try to understand what is pendency, what is suit, what is proceeding, what do you mean by transfer or otherwise dealt with. All these terms also must be clear to you. Then moving ahead at the last part, it says that under any decree or order which may be made therein, except under the authority of the court on such terms as it may impose. Now, this means that the court may allow you for such transfer to be done. But is that a general rule? Does it sound like a general rule to you? No, because you read except under the authority of the court on such terms as it may impose. So this gives us an idea that the court may allow such a transfer to be done, which is not so allowed under section 52, provided there are certain terms and conditions that the court is imposing on you. Okay. So to simplify, if this has been, too much for you to understand, just to simplify, if there is a suit, if let's say A has filed a suit against B, okay, I am writing suit, but the other term is it can be a proceeding also, right? If there is a suit or proceeding going on between A and B with respect to a particular immovable property, so I'm drawing a house for you for your understanding, okay? Now, in this particular situation, while the court was yet to decide whether this house belongs to A or to B, A has the possession of the house. He simply goes and sells the house to C. Now, what will happen if the suit later ends up declaring that the house belongs to B? What will be the right of this particular third party in this given situation? So to address such sort of a scenario, we have section 52, which covers the concept of doctrine of lis pendens. So this is the brief understanding with which you move ahead. Now, we also have an explanation attached to this particular provision, okay? Very important for us to understand pendency. Now, I will not get into the explanation of this. Before that, I will first take you to an example, okay? Try to understand this example. If you have seen any, torts case or any contract law case in your first year, just try to relate it with that. If I am a landlord, okay, and B is my tenant, or let's say B is not even a tenant, I am the owner, and B is a trespasser, even worse, okay? Now, when B is trespassing on my property, every day I see that B trespasses on my property and goes to his workplace. Now, in this particular situation, I can sue B and the court will give me a remedy stating that B will not be allowed. B is a party who's trespassing. I should be granted compensation. And in addition to that, the court will say that you are not allowed to trespass or enter into A's property. Now, this is something that has been settled between A and B. Will it also be binding C? Does it happen that now C, because of a suit being decided between A and B, now C can also not trespass on my property? No. Maybe I am now not the owner. I am rather a tenant now, and C is my landlord. And he is entering into my property for all lawful reason. So can I tell him, listen, see, you can't encroach on my property because of a decree that exists between A and B? That cannot be so, right? So this is the general rule that I am discussing about. This is the general rule as to whenever there is a court order, whenever there is a decree of a court, it will be binding on the parties. Generally, this is what is followed. But lis pendens acts as an exception to this particular general rule. How does it act as an exception? You will have to keep this example in your mind. So the example that I've given you right now is that generally it is the party to the suit on whom this particular decree will be binding. Okay, now let's relate it with an example of this pendants. A and B are two properties. Okay, they are two people. These are two brothers. So A is brother one and B is brother two. Now, while the suit was pending, there was a partition suit that was filed between them. While the suit was still pending, A, understanding that I may not win this, goes ahead and transfers this particular property or a portion of the property to a third person, C. Okay. Now the suit is still pending. After the suit was filed, A has actually transferred this property to C. What will be the right of C in this particular situation? Do we need to implead C? First question that should come in your mind naturally is, do we have to add C as a party here? First thing. Secondly, if he is not added as a party, if you have not added him as a party, what will be the situation? Will this decree be binding on C? Generally, what happens, we do not bind a third party, right? But in this case of lis pendens, will it be binding on C? Yes. No matter whether you implead C as a party or not, it will still be binding on C because of the doctrine of lis pendens. Now, ma'am, you have used this term lis pendens and pendentility so many times. What does this really mean? So, pendens, as you can understand, means during the pendency. And lis means suit. So while the suit is pending, whether you can transfer a property or not is something that is based on lis pendens. So from this example that I have drawn over here, you understand that there will be three parties in case of lis pendens to be applicable. And if the third party has been involved, it is not mandatory. Okay, a recent judgment of 2024 has come wherein we say that you can definitely implead this particular third party or the new transferee or the buyer of the property in the suit, but it is not mandatory. Even if you do not add the third party as a party to the suit between A and B, between the two brothers, it will still be binding on that particular third party. So I hope these basic points you have understood so far. Now, why did we actually introduce the concept of lis pendens? Okay, so firstly, you must know that there is a case of Bellamy versus Sabine. Okay, Bellamy versus Sabine. This is an English case, Chancery Court, from Chancery Court, wherein we actually firstly recognize this concept of doctrine of lis pendens, and that is why it is something very essential and landmark also. So you must refer and you must read and write this case in your answer. You can expect a MCQ asking you whether this case is related to the concept of fraudulent transfer or a transfer, contingent transfer, or lis pendens. So you must know that firstly, this is a case related to lis pendens. This is an English court case that is of 1857. So after that, Transfer of Property Act came into picture, 1882, wherein we have codified the reasoning that was given here under section 52 of the Transfer of Property Act. Also, the court here said that we have to recognize and we have to acknowledge that there must be a mechanism of lis pendens notice, that this particular third person who has bought the property, he must be notified, he must have the understanding or knowledge about the pendency of the suit. So these are crucial points related to this particular case law. I will be referring to the landmark judgments of India, so that we get clarity with respect to the topic. So first we understand a landmark case which has been time and hours against in MCQ. That is why I've given you the name of the case law. Now you can refer to this particular maxim which says that there should be nothing new. Okay, you do not have to introduce anything new while the suit is pending. So as I said, while the suit is pending, do not make mortgage, do not make sale, do not make any sort of transfer or otherwise deal with the property. But this is, again, see, you can do so, but you must understand that whatever the of the court is going to be, it is going to be binding on the third party. Now, when I say you can do so, you have to understand from that sentence that if you make such a transfer will not be void. Okay, so it is not void. Even though the language of section 52 is prohibitory in nature, it is preventive in nature, but still the outcome will not be void. It would rather be subject to the outcome of the court. Subject to the outcome of the court. What do I mean by this? That if the court is giving the decree against the seller, will it be binding on the buyer? Yes. So it will be accordingly binding on the new person who has bought the property. So that is why we say that it will be subject to the outcome of the suit. So you must buy such a property knowing and understanding the consequences of the same. Then I've written in the first part that this is a preventive relief. Okay, why is this a preventive relief? I will go to the recent case law also, wherein we understand and we say that whether you are supposed to ask for injunction or can you simply rely on section 52 of the Transfer of Property Act. Okay, so we will do this discussion, but for now we understand injunction is also a preventive relief and section 52 is also a preventive relief, which is giving you a caution that you are not supposed to transfer or you're not supposed to deal with the property during the pendency of the suit or proceeding. This has been done to bring efficiency and expediency in the final disposal of a suit. The whole idea of codifying lis pendens or doctrine of lis pendens is what? That we do not want that C to come later and say that, okay, I was not aware, I was not impleaded as a party, I was not aware of the pendency of the suit, or that the title of the suit has been contested in any of the particular suit or proceeding. So the idea is that we do not give you that particular window only, and we rather by the virtue of law are telling you that you are notified. There is constructive notice from our part that you will not deal with such sort of property, and if you deal with such sort of property, you are taking that chance knowing the outcome of the same. Okay, this is the first point that I explained you when I gave you the example of trespasser. The general rule is that only the parties to the suit are bound by the outcome, but the exception is lis pendens, wherein we understand, wherein we acknowledge and say that the any party who is deriving its title can also be considered and will also be bound by that particular suit. Okay, then we move ahead that the buyer. So I've written at the third point, if you see, that the buyer who's buying the property from JD, JD is the judgment debtor. So if you are a judgment debtor and you're buying a property, no right will be, you will not get a right to restrict the execution of a decree. Okay, so we have discussed the first part. Then this also that I've told you in brief, that this does not per se annul the transfer. When you are transferring that particular property and when C is buying it, knowing about the pendency of the suit, it will not annul the transfer. It will not make it void, but will only be subservient to the right of the litigating party. So if A has won the suit, A, B are there, A has sold the property to C. Okay, I'll keep saying and keep talking about C. Just remember that C is the third party. Okay, so what about this third party's right, ma'am? He paid all the money to A. He did not know about the lis pendens that is there, or maybe he knew about the lis pendens that is there. Still, he bought it, but he has bought it for money. To answer all of this, just remember this transfer is not void. If A wins the case, it is a win-win for C because he will get the entitlement over the property. If A loses the case, then in that situation, you can't go against the judgment. C's right will be subservient to the right of the litigating parties that are A and B. Okay, so this is what we have written and this is what I have explained you now as well. Okay, now this doctrine was recognized primarily because of two reasons. Okay, the first reason is notice to the entire world. So we say that there is constructive notice. Whenever there is a suit that is pending, it gives you a constructive notice, that deemed notice, that you are aware about that particular suit being contested, and you must buy it or deal with it knowing the the outcome will be your rights will be subservient to the litigating party. So that is about the doctrine of notice to the entire world. And the second is about necessity. Okay, what is the context of necessity here? This is public good. So whenever we are talking about this particular doctrine of lis pendens, this is basically revolving around public good, that we want to keep the right of all three parties, A, B, and C. Everybody's right should be kept, and everybody should be enjoying their rights. So keeping in mind that if A is the rightful owner, he has all the means of transferring the property to C. If he is not the rightful owner, it is the property of B, and he should not be, either A or she should not be getting a entitlement to contest that particular right. So that is why we also acknowledge it by way of necessity and public good, that nobody should interfere during the judicial proceedings and should not be dealing with that particular property. The Supreme Court also has said recently that once a transaction is found to be hit by doctrine of lis pendens, the defense of being a bona fide purchaser, as I said, C has bought the property paying money, so he is a bona fide purchaser, or the lack of notice, or that he did not know about it, these defenses will not be available when this particular transaction is found to be hit by doctrine of lis pendens. So these all have to be kept in mind while you are dealing with a property. Now, starting with the first point as to what is pendency. So what do we generally think? That once you reach to the court, the matter will become that it is pending before the court, and the minute you get a decree, we can say that the pendency has come to an end. But is that so, or is it something that will extend and will move beyond that? So now for this, let's move to the explanation of section 52. Okay, we are trying to understand the term pendency, and we will get our clarity with respect to it after we read the explanation. So let's read the explanation. For the purpose of this section, the pendency of a suit or proceeding shall be deemed to commence. Okay, so when does it commence? And it is deemed to. Okay, so again, a fiction that we are putting, that it will start from the date of presentation of the plaint. The day you present your plaint, it will commence. Okay, till when will it go on? We are not deciding, but it has started when you present your plaint. So if you have heard of the term suit, and if you have referred to CPC, you must be knowing that it starts with presentation of the plaint only, or the institution of proceedings in a court of competent jurisdiction. So it can be by way of plaint, or it can be by way of the institution of proceedings. Either. Then it must be before a court of competent jurisdiction. Very important. Unless and until you are before a court of competent jurisdiction, section 52 will not apply. So equity on both the parties, that you have reached to the court of competent jurisdiction, and then only this particular doctrine will start running. And it will continue until the suit or proceedings has been disposed of by final decree or order. Okay, so let's say my final decree or order comes here. So this will run from here and it will go on until this. But is there something else also to it? Let's read beyond this. Okay, so it will continue until the suit or proceeding has been disposed of by final decree or order, and the complete satisfaction or discharge of such decree or order has been obtained. Not just this, but rather what else is important? That complete satisfaction, whatever your decree suggested. If it said, please give possession to B, have you completed the satisfaction of the decree? Have you actually given the possession to B or not? That will also be considered to be a time period when the suit is pending. Or has become unobtainable by reason of expiry of the period of limitation prescribed in the execution thereof for the time being in force. So I hope you understand period of limitation. What are we basically implying here is that you get your decree. After this decree, till when will it actually continue? Till the execution is done. Okay, the satisfaction is done or the execution is done. Or if you have, it has still not been executed, you wait till the period of limitation to actually challenge this is over. Okay, so can you challenge this particular decree or order? You can do so. So your limitation will continue till that particular time period as well. So that is why it is written. Now if you read it in the context of the red part, complete satisfaction or discharge of such decree or order has been obtained. So maybe it was about possession and you have delivered the possession, or it, because we are talking about immovable property, okay, or has become unobtainable. So either this, or it has become unobtainable because the period of limitation has expired now. So this entire period will be considered as your period during which you can say that the suit or proceeding is pending before the competent authority. Okay, so remember, this has been asked time and again. Okay, this ye bahut favorite question hai, wherein they ask you that whether this particular execution proceedings, in execution proceedings, whether doctrine of lis pendens will be applicable or not. So you have an explanation which clearly mentions about it also to be included. Okay, so accordingly remember that pendency starts when and it ends when, and always remember to read the explanation of section 52, because we miss on that and there are so many questions that are asked from that itself. Now I have given you an example of insufficiently stamped plaint. Okay, so let's say A files a suit against B and this particular plaint was not sufficiently stamped. Okay, not sufficiently stamped. Now there are two things that can happen. Okay, first is the court rejected this particular plaint. Now what will happen? Let's say it rejected it on 1st of January 2023. You took your 7 days and you fix it and you file a fresh plaint on 7th of January 2023. This is first position that I am discussing. Okay, because these are questions that are asked in your problem based questions. So first is this, that it was rejected because of the deficiency and now you fix it within 7 days and you file a fresh one on 7 January. Okay, the other one is that the court doesn't reject it and the court lets you fix the deficit. Okay, the court says that okay, whatever amount is to be paid, you pay it in the court itself. Now in both the situation, let's say within this 7 days period of time when that was rejected and you were trying to fix it, B transfers the property, will it be falling under lis pendens? Will it be bound by lis pendens? Will this be considered as pendency or will it not be considered as pendency? Okay, please give your answers in the chat box whether this is pendency or not when you are trying to fix after the plaint was rejected, contrary to the other situation where the court has accepted and the court lets you fix the deficit of the amount to be paid in the court. Is this pendency or is this pendency, or are both pendency? This is for you to understand that whether that entire chain that I had drawn in the beginning, that your plaint or your has been instituted and your suit has begun versus till when will it go on. Okay, so this is one favorite question that has been asked a lot of times. Then you can mention this particular case law also related to the same example that I'd given you. If there are two parties and one party during the pendency of the suit tries to transfer that particular property to the other one, okay, so the third party will have a right subservient to the rights of the litigating parties. Okay, so you can mention this case law. Then we talk about appeals and execution. As I said, all this will also be covered in the term that is pendency before the court. Okay, just to give you an example for appeals and this, let's say there is a suit related to mortgage, okay, and you ask for foreclosure, remedy of foreclosure. I am not sure how much of are aware about the term mortgage foreclosure, but we'll be dealing with this in our classes, and then at that time we will understand this as well. But just for your brief understanding, if there is a suit of mortgage, okay, and if there is mortgage and there is a suit related to foreclosure, in that particular situation, not only the time when you get the foreclosure decided in your favor, also the time when the sale is done and you get the money, all this will be considered as pendency. Okay, so from the first stage till the last stage where you get your money will be considered as the stage wherein this entire proceeding is pending. Okay, so always remember, those who know, they can write this as an example in their answer. Those who do not know, we'll be reading about mortgage, and then you will understand what is this, what are these terms. This can be new also for a student of law, and how is this in the context of lis pendens being covered under the term pendency. Okay. Okay, then we also talk about suit and proceedings. So, one second. So what are suits and what are proceedings? All of you must be knowing what are suit. Can you give me example of suits in the chat box if you are aware? There can be a suit with respect to specific performance, right? It can be with respect to contract also. It can be with respect to any of the rights. But what are these proceedings? So it can be revenue proceedings. Okay. Now, in the last class, I dealt with the concept of arbitration. So you have to tell me whether arbitral proceeding or arbitration proceedings, if there is arbitration going on between A and B, okay, and this is with respect to the same subject matter, which is the same subject matter which you have now transferred to C. So whether this will also be, this proceedings will also be a part of this particular section 52 or not. Okay, so give me an answer in the chat box whether arbitral proceedings will also be considered as proceedings or not. Okay, now it must not be a collusive suit. Now what is collusion or sham or pretense that we can talk about? So see, the entire concept of property law is based on equity based principles. Okay, now also recently the court held that even those states wherein TPA is not per se applicable, you can still invoke section 52. Okay, if lis pendens is not applicable, you can still invoke the principle of section 52 because it is based on equity. So when we are talking about equity, the justice has to be done to the parties or they have to be remedied. You have to keep this in mind that the suit that has been filed must not be a collusive suit. Okay, it must not be a suit which has been placed because of a sham or only and only to, to defraud one of the parties. So a collusive suit, I'll give you an example. Let's say there is A and B. Now, there was, in the terms of contract, it was mentioned that I have given you advance payment. Okay, let's say advance payment of 10,000 rupees. I have given you advance payment of 10,000 rupees. I promise to deliver the possession of the property to you by 1st January 2023. In case I fail, what will happen if I do not give you the possession? You can forfeit this advance payment. Okay, so from A's part, he says that if I do not give you the possession, you can forfeit my advance amount of money. And in case you do not pay me this particular payment, it will be double that you will have to pay off 10,000. This is the understanding between A and B for a particular contract. Now, A gets to know later that the house that he's trying to sell to B, he is getting a better offer from a third person, X. Okay, and he doesn't want to sell his property to B, nor does he want to pay twice the amount of the advance payment made. So in that case, he enters into an understanding with his brother C. He says, why don't you file a suit for this particular immovable property? And in between, when he will be asking me to give the possession, this particular transfer will be barred by doctrine of lis pendens. Okay, so what has he done? A has entered into a collusion with his brother, saying that please file a suit with respect to the same subject matter, so that when I transfer this later to B, this will be barred by doctrine of lis pendens. So court in this particular, will doctrine of lis pendens will be applicable here? It will not be applicable because it must not be a collusive suit. Very clearly, section 52 says that it must not be done to defraud any of the parties or to defraud the court in the given situation. So that is about collusive suit. Now the transfer can be anything, absolute or partial. So either of the transfer is barred, but only and only it will be allowed when the court accepts and the court acknowledges that you can make such a transfer in a given situation. Okay. Now, moving ahead, we talk about or otherwise dealt with. Now, what is this meaning, ma'am? What is the meaning of or otherwise dealt with? Whether if the property has not been transferred, what else can we do with the property which can fall under section 52? So what all do you think can be done here? Can you think of any example or otherwise dealt with? So basically section 52 is telling you that while the suit is pending before the court, you do not transfer that suit, okay, or you do not deal otherwise with the suit. Now what is this otherwise dealing with the suit? So can you make partition when the suit is still pending before the court? Can you make or can you write a release deed with it? Or can there be a surrender for that particular same property? No. So all these will be categorized and considered under the concept of otherwise dealing with the property. So neither transfer is allowed nor any sort of dealing with the property is allowed as per section 52. If you do so, obviously it will be subject to the outcome of the suit or proceedings. Now we have this particular case law also. I'll just tell you very briefly. Let's say two brothers were there, X and Y. Okay, and while this entire suit was filed for partition, X has done certain transfers. Okay, now why has he done this transfer? X is a karta. This suit is for partition. And while the suit was still pending, X makes transfer of two portion of the property. Okay, both the transfers were done for fulfillment of his personal obligations. He had taken loan, and for those personal obligations, he had taken one loan from his son-in-law, and there was one more loan that was taken. For both these, it was for his personal obligation. Will Y be bound by this particular transaction? No. Why? Because you are not allowed in any manner to deal with the property for your payment of your loan amount or for transferring or for partition. For any of the purposes, you should not be doing it while it is pending before the court. And if you do so, it will be adjusted from your portion of the property only. Okay, so that is what is we have seen in this particular case of Jayaram Mudaliar versus Ayaswamy. Okay, then what will be the status of transfer? So as we discussed in the beginning, that it will not be void. Okay, it will not be void, but at the same time we have to remember and understand that it will be subject to the decree of the court or the order of the court with regards to whatever the court is deciding. Accordingly, it will be subjected to that. Okay, then we move ahead. We have this recent case law. This is 2024, wherein the court has said that you should always apply for an injunction rather than waiting for section 52's remedy only. So what is the court basically trying to tell us here? See, when we talk about section 52, section 52 definitely gives you a remedy and says that any transfer that will be done, it will be subject to the outcome of the court. But at the same time, if let's say the contract is for specific performance or for delivery of the property, the court has in this particular judgment highlighted and said that it is always beneficial for you to go and seek the remedy of order 39 rule 1 CPC and apply for injunction to be granted to you, so that you can restrain the party from transferring the property. Now this is absolutely contradictory to the old position, wherein the courts had said that it is absolutely fine for you to not apply for injunction and wait merely for section 52. So that is why if you get a question now in your exam, either asking you directly for doctrine of lis pendens or speaking about a situation, a problem based question, you can definitely mention this also as an additional remedy, that the first recourse, that the alternative recourse can be firstly to apply for injunction, then in addition to that, obviously if a transfer is done, it will be subject to this particular doctrine. Okay, so this is a recent update that we have covered here. Now let's try to look at a few questions and try to find out what all do you need to write in the answer. Before that, let me just also give you a very brief hint. If you have access to your Bare Act, please refer to your Bare Act. Okay, I'll tell you, I can always show you the Bare Act online as well. But while I'm showing you the Bare Act here, you should have your own hard copy of the Bare Act, wherein you read and you understand and you keep it with yourself. Okay, so you can, some people do not write anything on the Bare Act. Some people tend to write a lot. So it's absolutely on you. But the whole point I'm asking you to refer Bare Act for this particular provision is for you to see that what all changes have been done and at what stage. So you can expect the MCQ with regards to what are the terms that have been substituted. So for example, if you refer to the term collusion, okay, it is not collusive. You will find that this has been this has been added later. This was substituted rather in 1929, and it took away the term a contentious suit, right? So all these term active prosecution is something that we have removed, and now we talk about pendency. So these are terms that you must refer to, look at, and also remember the year. Okay, so 1929 is the year where a lot of changes were made in Transfer of Property Act. You can also, write your answer when you're making your notes. Also put a star and then write down that before 1929, what was the term? That was active prosecution. Now you see, active prosecution versus you are writing pendency. So much of change is there, so much of difference of nature of the terms is there, right? The entire proceedings may change, the entire idea may change. So whatever you are referring to, always make your notes with regards to Bare Act wherever there has been substitution or wherever there has been amendment or changes that have been made. Okay, so this is also very important with regards to your previous year questions and for your MCQ based questions. Now I put a mixture of few questions. One is very straight away, directly asked in 2022. So very recently, I may say, explain the principle of list pendants. So you get a 5-marker question, you get a 10-marker question, 15-marker question, depending on the judiciary. You have to remember that the content must cover all the aspect in brief or in expansion of the elaboration of whether you talk about pendency and you explain it. If it is a 20-marker question, you may explain it at great depth, right? If it is a 10-marker question, you will restrict it. But you must touch on all the essential ingredients of section 52 that we have highlighted and covered here. Then list pendants is a well-established principle to transfer of property, foundation of which does not vest upon notice. Okay. So as I said, Bellamy versus Sabine was the case wherein the court enunciated and the court said that there must be list pendants notice that must be given. But now we have moved from the notice doctrine to the necessity doctrine, and we say that we have recognized this principle on the doctrine of necessity. So you do not really have to give notice. It will be deemed that it is going to be binding on the third party. So list pendants is a well-established principle of transfer of property, foundation of which does not rest upon notice, actual or constructive. It rests solely upon the doctrine of necessity. Explain this in the context of Bellamy versus Sabine and other relevant case law. So this was asked in 2019. So you can discuss on both the doctrines that I discussed with you, notice and necessity, and then in the context of the relevant judgment of the new judgments, you can mention that how it, जैसे मैंने आपको बताया, one of the case law that I discussed with you, that therein the court has highlighted that it is going to be binding on the parties. They cannot take the defense of not having knowledge, or they cannot take the defense of being a bona fide purchaser. This is by virtue of law itself that is there in Transfer of Property Act. Then there is a contract to sell a house between A and B. B files a suit against A for specific performance of contract. So they have decided that they are going to, one is going to sell the house to the other, and now he is asking for specific performance of contract. So there is a suit that has been filed. So list pendants will begin the day the suit is filed. While the suit is pending, A sells the house to C, who doesn't have notice of the pendency of suit. Again, very clearly touching on the same doctrine of notice, wherein even if you are not aware of the pendency of the suit, how will you decide suit is decreed in favor of B? Can the decree be executed against C or not, right? So you must talk about the third parties, right? You must talk about the notice doctrine here. And then you say that using the doctrine of necessity, we may imply that it will still be binding against C. We do not have to implead C, and we do not have to per se inform C either. Okay. Then describe list pendants. Does it apply to execution proceedings? So 2019 again, wherein they have asked about execution proceeding. Can you write an answer without talking about the explanation to section 52 here? You cannot do so, right? So you must mention explanation of section 52 to answer this particular last question that talks about doctrine of list pendants. and does it apply to execution proceedings or not? So to sum up, let's just quickly revise that what all have we covered. When we are talking about section 52, what all do we need to look at? So firstly, that there must be a suit or proceeding. We have to understand that what is a proceeding or what is a suit. I gave you an example and a homework also, that whether arbitral proceedings will be considered here or not. Secondly, this must be pending. It has not been decided. It must be in its pendency. When does pendency start and when does it end? We have discussed that in context of the explanation of section 52. Okay, when does it end? So if your appeal is considered to be a continuation of the suit only. Okay, so till your appeal is decided, or if appeal has not been made, execution is done, or if execution is also not done, then you wait for the limitation period to end. So all this will be considered as the pendency of the suit. So there must be a suit or proceeding which is pending. This suit or proceeding must not be collusive in nature. Then we say that in such a situation, there will be considered that it will be binding on the third party, on the transferee. So if there is a judgment debtor and the transferee or the buyer has bought a property from the judgment debtor, so will he be able to obstruct the execution of the decree? He cannot do that. Okay, then before you write your answer for all of this, just you mention about the exception also, that the court may allow, but this is not the general rule, this is the exception rule, that the court will allow it only and only specifically mentioning the whatever are the terms and conditions with respect to allowing of such a thing. You must remember the subject matter for this particular provision. Okay, when I say subject matter, when you are reading TPA, when you are reading Transfer of Property Act, you must see in which chapter which section is following. Okay, because see, these are tricky questions that you get. If you refer to chapter 2, the title of chapter 2 says transfer of property by act of parties, transfer of property, whether movable or immovable, and then you see that this entire chapter is talking about both movable and immovable property. But later when you come to chapter 3, it talks only about immovable property. Fourth, only about immovable property. So you must remember and understand that what is the subject matter. If you get a question, problem based question, wherein they are talking about a movable property, you feel okay, I have read list pendants and the entire facts, this they put the subject matter as a movable property. Okay, and you feel that okay, I have read list pendants and doctrine of list pendants will be applicable here. No, you have to remember all the ingredients and accordingly write your answer. So in that case, you may recommend the remedy of injunction, but you cannot recommend list pendants because it will not cover, it will not be covered as per this particular subject matter under section 52. So I hope list pendants, in very briefly we have tried to discuss it. There are many new judgments that have come which we'll be discussing in our class. So before I conclude, I would just like to briefly tell you that we have our course that is starting from 15th of January for judicial services examination preparation. You can join us for the course. We have our handwritten notes, we have these set of notes which we'll be providing you with, wherein you will get good new judgments as well as the old judgments, a comparison wheresoever it is needed, and also we'll be discussing all the case laws that have been relevant or that are relevant or that have tried to cover any of the previous year question, be it subjective or be it a MCQ based question. Okay, so if you have any doubts, let me just see. All right, so no doubts that have been asked. Okay, if you get doubts later, if you will watch this video later also and you feel that you have any doubt, you can drop your doubts in the comment section and I will be more than happy to address it later. Thank you so